All right, let's get into a legal case that really turns on just one tiny but super important detail. It's a distinction that actually creates this wild loophole in the law. This is a story all about rules, your rights, and why, believe me, the fine print on your housing agreement is everything.
So, picture this, right? You live in a community, you get into it with management over something. You do what you're supposed to do. You file a complaint, you cite the law that you're sure protects you. But what if their lawyers turn around and say, yeah, about that law, it doesn't apply to you?
Okay, so our story kicks off with a pretty common situation, a resident's complaint. It really just started from that feeling that, her community's management just wasn't playing by the rules.
So on one side, you've got Charlotte Tande. She's a resident at a mobile home park called Wintergardens, and she's alleging that the management is breaking two really key Arizona laws, one about open meetings and another that says they have to show her the financial records. So she did what pretty much any of us would do, right? She filed an official petition. Seems pretty straightforward, or so you'd think. But this is where things get interesting. Wintergardens' response was, well, it was a real curveball. A defense that sent this whole case spinning in a direction nobody saw coming.
And this is where the legal strategy just gets fascinating. See, Wintergardens didn't even try to argue the facts. They didn't come back saying, oh no, we did hold open meetings, or of course we gave her the records. Nope. Instead, their lawyers filed a motion to just dismiss the entire case. And their argument? It was a total bombshell. Those laws Tande was citing, the very laws that govern HOAs, they claimed those laws didn't apply to them at all.
And bam! Just like that, the whole game changed. This case wasn't about meetings or financial records anymore. Not at all. It all boiled down to one single, fundamental question. Is a cooperative, like Wintergardens, legally the same thing as a planned community? And planned community, by the way, that's just Arizona's fancy legal term for an HOA.
And to answer that question, the judge basically had to put the whole idea of ownership itself on trial. And that right there is the real heart of this case.
Okay, so the law that Tande was pointing to is Arizona's Planned Communities Act. Now, it defines a planned community as a development where the members are, and listen up because this is the most important part, they have to be owners of separately owned lots, parcels, or units. In other words, your typical HOA where you actually own your house and the piece of land it sits on.
I mean, that specific phrase, that's the whole legal test right there. For this law to even apply, the residents have to individually own their piece of real estate. Everything, the meetings, the financials, Tande's entire case, it all hangs on just those few words.
So, here's the crucial difference. Let's break it down. In an HOA, you own your lot. Simple. But in a co-op, the whole structure is completely different. A corporation, in this case Wintergardens Co-Operative, owns all of it. The land, the buildings, everything. As a resident, you don't actually own any land. What you own is a share in that corporation. And that share is what gives you the right to lease a specific spot. So you're basically a shareholder and a renter, but you're not a landowner.
So with that key distinction between the two ownership models laid out so clearly, the judge was finally ready to make a call.
And things moved pretty fast from there. Wintergardens filed that motion to dismiss on July 10th. A couple of weeks later, on the 24th, Tande filed her response, basically doubling down and insisting they were a planned community. But by September 5th, the judge had the final order ready.
And here it is, the core of the whole decision. The judge, Tammy Eigen here, she put it really plainly. She noted that there was absolutely nothing in the paperwork to show that the residents were, quote, owners of any separately owned lots, end quote. They owned shares in a corporation. They did not own individual plots of land. End of story.
And that was it. The judge granted the motion to dismiss. Charlotte Tande's entire case was thrown out. And get this, it wasn't because she was necessarily wrong about the meetings or the financial records. It was because the entire legal foundation of her complaint was built on the wrong law.
The judge's final takeaway was actually pretty simple. Because Wintergardens is a co-op and not a planned community, the Arizona Department of Real Estate, the agency Tande went to for help, had zero legal authority here. She had, quite literally, knocked on the wrong door.
This whole outcome really hammers home a powerful lesson for anyone living in a managed community. The fine print, it really, really matters. In fact, you could say it's everything.
And yeah, that decision was final. A couple days after the dismissal, Tande did email the court, but the judge's response was, well, it was definitive.
The court stated it could take no further action and, this part's crucial, it cannot provide parties with legal advice. So for this particular case, that door was officially slammed shut.
So what are the big takeaways here? Well, first and foremost, you have got to know your community's exact legal structure. Is it an HOA, a co-op, a condo? Because as this case proves, your rights can be completely different. A proprietary lease in a co-op is just not the same as owning a lot with a deed, and that single difference can determine which government agency, if any at all, can actually help you when you have a problem.
Which kind of leaves us with one last thought, doesn't it? An entire case with very real consequences for a resident and her rights. It all came down to a single definition buried in a law book. And it really makes you wonder, do you know the precise legal structure that governs where you live? It might be a really good time to go check that fine print.